She wasn't simply released, she stepped out into the open. And now those who had watched her reshape the Department of Justice over the years, piece by piece and rule by rule, are unwilling to let her walk away without challenge, moving forward with new filings that are far more extensive than before, built not only on earlier concerns, but also on everything that followed, including her sworn statements and actions taken openly while holding one of the most powerful legal roles in the country, with every document carefully preserved. And what many people didn't realize was that a specific rule had long protected her, as within the Florida State Bar she remained beyond reach while serving as Attorney General, not because there was no evidence or lack of attention, but because a regulation prevented investigations into executive officials confirmed by the Senate, effectively. Acting as her shield, even as 70 experienced attorneys, former judges, legal scholars, and 2 retired Florida Supreme Court justices raised serious ethical concerns and called for a full review, only to have their complaints dismissed due to that same rule. But that was then, and once she left office and returned to private life, that protection disappeared. And the same legal voices moved quickly, filing again almost immediately with a stronger and more comprehensive complaint they believe carries far greater weight than anything submitted before. The wording matters deeply here, because this all traces back to the original complaint filed before her attempts to indict 6 members of Congress, before the claims that she misled Congress about the Epstein files, before alleged violations of the Epstein Files Transparency Act, and before accusations that she used improper subpoenas against the Federal Reserve Chairman, meaning that initial grievance was only the beginning, and once it was dismissed due to the rule that shielded her, everything that followed was added on top, creating a far more extensive case built around a pattern of alleged false statements, questionable prosecutions, and misuse of authority. And, now that the protection is gone, a single, comprehensive filing brings all of it together, including the moment she addressed Congress directly when Representative Ted Lieu asked whether the Epstein documents contained any evidence of illegal activity by Donald Trump, and her response was not qualified or carefully framed, but a direct and unambiguous no, not softened with context or legal caution, but delivered clearly under oath. And that single word is now being examined as a potentially false statement within a legal time frame that allows for consequences, especially since even a slight qualification could have changed the interpretation, yet she chose not to include one, making that response a central focus in the broader argument about accountability and the standards applied to those in positions of power. Because of what appears to be a failure to fully uphold the legal standards she was sworn to defend, the Attorney General of the United States, the nation's top law enforcement official, now seems unable to counter accusations that she made false statements during her testimony before Congress. And that single word she delivered under oath has now become part of a much broader ethical complaint, reflecting what critics describe as a wider pattern, including actions taken against figures like James Comey and Letitia James, as well as attempts to pursue Mark Kelly and other members of Congress for stating a well-established principle that military personnel are obligated to refuse unlawful orders, something widely accepted as a basic part of civic responsibility, yet efforts were reportedly made to treat such statements as criminal. And when Jerome Powell declined to adjust interest rates based on pressure and instead followed economic data, he too became a target of questionable legal actions, including subpoenas viewed as improper, while critics argue that legal processes were stretched further through the use of grand juries in ways that raised concerns about legitimacy, and lawsuits appeared to follow individuals publicly labeled as adversaries by Donald Trump, not necessarily due to evidence of wrongdoing, but seemingly in response to public statements, all of which, according to observers, broke long-standing ethical norms within the Department of Justice, even as efforts were made to weaken the very oversight systems meant to hold legal professionals accountable. And now, with those protections gone, she faces the same accountability framework she once operated within, as the push for action is no longer coming from political figures, but from respected members of the legal community, including former judges, attorneys, and even retired state Supreme Court justices who understand both the damage alleged and the rules that govern such conduct. And precedent makes the stakes clear, as figures like Rudy Giuliani, John Eastman, Kenneth Chesebro, and Jeffrey Clark have all faced disbarment following investigation, showing that these outcomes are not theoretical, but well-established consequences within the legal system. Following their roles in efforts tied to the 2020 election and actions during Donald Trump's first term, lawyers like Rudy Giuliani, John Eastman, and Jeffrey Clark ultimately lost their licenses, setting a clear precedent. Yet critics argue that Pam Bondi's situation may be even more serious, as she is accused not of working from the outside, but of using the full power of the Department of Justice from within, its staff, budget, and prosecutorial authority, to pursue actions seen as deeply improper over an extended period, raising a critical question about whether one of Florida's most prominent lawyers will now be judged by the same standards, especially under a state bar system associated with Ron DeSantis, which has faced scrutiny over how it handles accountability. And there is reason for doubt, since earlier complaints were dismissed due to a technical rule that shielded her while in office, reflecting a broader pattern where those closest to power have often avoided consequences. Yet state bar councils are not meant to function like political bodies, but as licensing authorities responsible for determining who is fit to practice law, meaning their credibility depends on consistent enforcement of ethical standards, because allowing proven misconduct, from misleading Congress to misusing legal authority, to go unaddressed would not just affect one individual, but undermine the integrity of every lawyer they have licensed. And this kind of institutional pressure operates independently of political alliances or influence, making it a defining test of whether the system will uphold its own standards, especially as new developments in Florida begin to add even more weight to the situation. In Mar-a-Lago, located in Donald Trump's home district, a recent election saw a Democrat win in an area once considered reliably stable, marking a dramatic shift of more than a dozen points in a single cycle, while Trump's national approval ratings have slipped into the mid to low 30s, signaling a broader change that would have seemed unlikely just a year ago, when accountability in that environment felt nearly impossible. Yet even as the landscape begins to shift, some argue that disbarment alone may not be enough, suggesting that Pam Bondi could still benefit from the influence, connections, and access she built during her time in office by transitioning into roles like consulting or lobbying, especially in a climate where public attention, even for controversy, can sometimes enhance visibility rather than diminish it. And while that argument carries some weight, disbarment remains a serious consequence, one that closes doors within respected law firms, corporate legal departments, and professional institutions that depend on ethical credibility, creating a permanent mark on record that follows every future opportunity and professional interaction. Unlike temporary headlines that fade over time and separate from that process are ongoing legal questions, including potential false statements to Congress and unresolved issues surrounding sealed Epstein-related documents, where the legal timeline may still be active if considered part of a continuing matter, meaning accountability could extend further depending on how events unfold. And past experience adds urgency to this moment, as when Merrick Garland assumed office after years of controversy, delays in action allowed key figures to move on before consequences could fully take shape, even after appointing Jack Smith, leaving a lasting lesson about the cost of waiting. And now the message for those in power is clear: accountability must be immediate and consistent, because avoiding consequences does not bring resolution, it only encourages repetition, and as a new, more comprehensive complaint moves forward, backed by dozens of attorneys, former judges, and legal experts, along with retired Florida Supreme Court justices, the situation enters a new phase, with previous protections gone, timelines in motion, and legal precedent already established by figures like Rudy Giuliani, John Eastman, Kenneth Chesebro, and Jeffrey Clark, all of whom faced permanent professional consequences. And, while she may have believed leaving office would end the scrutiny, the legal system, and those who carefully documented every detail, are now moving forward, making it clear that the process has only just begun, the clock is ticking, and without the protection that once shielded her, what remains is the record and the judgment that follows.